abused its discretion in ordering complete consecutive sentences. I'm not going to go into the facts in total detail because they're uncomfortable for everybody, including people in the courtroom today. But the court did, and the court determined that the victims in these cases were damaged severely, and we're not trying to minimize that, and that was in the record. But the court basically decided to impose complete consecutive sentences to protect the public from further criminal conduct by the defendant, and the offenses were reasonably related to the severity of the offense. You know, the state in their brief said that I was trying to seek a per se rule that no juvenile could get 24 years in prison. And when I looked at what I wrote, it sounds like that's what I said, but that's not what I meant. But you know, sometimes when you go back and look at what you wrote, he was 14. We think it's an abuse of discretion to give, and I'll reserve a minute for rebuttal. I should have said that, but I don't know that I'll have any. So I'm not sure how the court approached that or how this court should approach it. But when you look at consecutive sentences under the Perry case that's cited by both, first thing you got to decide is a person eligible for consecutive sentencing? Answer is yes in this case. So then the court would have to determine whether or not consecutive sentences were appropriate, and in the important parts, the second part, and to what degree. And that's where my argument comes in. To what degree should you impose consecutive sentences on an individual who committed the offenses when he was 14? It's our position that if you look at the record as a whole, that it's an abuse of discretion to order complete consecutive sentences based on what the court outlined. But when I was thinking about this and looking back at Perry, and I'm kind of quoting from, once a court determines that they're qualified for consecutive sentencing, like I just talked about, must determine whether to impose it and to what degree, based on the facts and circumstances of the case. It's my position, I don't think the court gave enough, in looking at the facts and circumstances, enough weight to the fact that we're talking about somebody who was 14 years old. The purposes and principles of sentencing suggest that, and I'm kind of quoting again, although statutory criteria may allow for the imposition of consecutive sentences, and here's what I think the key is, the overall length must be justly deserved considering the seriousness of the offense and be no greater than deserved or necessary. That's where I think we arrive in this case. Is the overall sentence, it's almost like the old thing of you don't see the forest for the trees, with the trees being each individual victim. We look at that, this was terrible, this was terrible, this was terrible, this was terrible. But if you look at the forest, at the end, we've now imposed a 24-year sentence on an individual who was a juvenile at the time. In Tennessee, as in most states, we have a juvenile court system for the very reason that we treat them different. And now the law has changed completely about the juvenile justice system. Doesn't apply to this case, but I think it's more progressive than what we had at this time. But I won't belabor the point. If the court has any questions, I think the court knows what my position is. Is some consecutive sentencing appropriate in this case? I don't know. If you were to ask me, well, Mr. Flanagan, if it is, what number would you pick? I would pick a number that is less than his age at the time. He was 14. If you ran 2 of these consecutive for a 12-year sentence, the record probably would support that. So that's our position. We're asking the court to either modify the sentence which the court has the power to do, or remand it back with instructions for another sentencing hearing.
You're not questioning the 6-year designation?
Not at all.
It's just a consecutive alignment.
It's the total consecutive is why I'm here. I mean, obviously, if we're talking about an adult with these fact situations and the damage done to these victims by a person who was an adult, I wouldn't be up here arguing that 24 years was too much. I'd be up here arguing. I'm thankful that's all it was. So that's my position. We don't argue the service of the sentence. We don't argue that it's 6 years. We don't argue that maybe it should be consecutive to some extent. Our argument is that it's an abuse of discretion to sentence somebody to 24 years for acts they committed when they were 14.
The defendant is 25 now? The defendant is 25 years old?
He's 25 years old now.
And these were 10 years ago then, these offenses?
Yes. Yes, he was born in 2000. So
did all the offenses happen when he was 14?
the ones he pled to, and there was, as you can, if you read the record in the sentencing hearing, there's kind of long, long period of time, different victims, different activities. But it looks like the two that he pled to, he was at 14, but he was underage in all of them that he was charged with. I know the trial court made a comment that, well, he wasn't a child, in some particular thing. Well, he was a child. He was under 18. If you're under 18, you're a child.
I thought I saw on the record somewhere that it was 14 to 18 when
Yes.
when these were committed.
Right, but I think the two he pled to were 14. But I could be wrong. But
The two he pled to, he pled
the
to
four,
Okay.
yes, under two different case numbers.
Okay.
But
And the reason for the reason for the consecutive sentencing was the trial court considered the number of times he committed these offenses, found him to be. Did he also rely on the fact that these victims were family members?
I was getting ready to mention that along with the relationship of the parties and things of that nature. And those are all factors to arrive at a conclusion that sentence should be consecutive. But I don't think we can stretch it to the point that they all should be consecutive. So that's my point. I'm not arguing that the factors of Perry weren't met in deciding whether they were consecutive sentences. It's at the end of it, to what degree, and the end result of the sentencing principles that we go by in Tennessee, that this is excessive. So, thank you.
Thank you, Mr. Flanagan. All right, Jen Weber.
Good afternoon. May it please the court. Lacey Wilbur on behalf of the state. Your Honors, the defendant is not entitled to relief in this appeal because the trial court did not abuse its discretion when it imposed consecutive sentences. The defendant, just to clarify, the defendant's indictment was from the time he was 14 to the time he was 18. So it's a span of 4 years. But what we heard at the sentencing hearing was activity that spanned from the time that the victims were in second grade to 11 years old, 5 to 15, 6 to 12 years old. The defendant was cousin to two of these women who testified. One of the victims who was in the indictment, the pre-sentence report shows that the defendant was in high school when she was in elementary school. And the trial court made it very clear that he was imposing this because the defendant was convicted of 2 or more statutory offenses involving sexual abuse of a minor, and he went through the following factors under that, saying this involved a long period of time span of undetected activity. It was the relationship between the defendant and these victims. He was cousin to 2 of them. He was best friends with RF's brother. They played baseball together, so they spent a lot of time together. Their families were very close friends up until this became revealed. The nature and scope of the sexual acts and the extent of the residual physical and mental damage to the victims. And the trial court said, I want it known for the record that these victims are speaking in a flood of tears, and they are testifying haltingly, and that they are very affected still by all this abuse that the defendant heaped upon them.
Just to clarify for me, there were 2 victims in the convictions that were pled.
Yes, ma'am.
But at the sentencing hearing, those 2 victims plus at least one other or other victims testified?
Yes, and it's a little confusing because the victim who testified is AK. Her older sister, that is unindicted activity because the defendant was under the age of 14 when he committed those acts upon her. I refer to her as AKS. She is referred to in the trial transcripts as AK2. And then RF is a named victim in the indictment, and she testified.
That's what I thought. I just wanted to
Yes,
clarify that for the record.
If there are no further questions, we ask that you affirm the judgment of the trial court. Just want to make sure I'm not walking away with you having a question.
All right.
Okay.
Well done. Thank you, Ms. Wilbur.
Thank you.
Thank you.
Mr. Flanagan?
In closing, I think the court can see, the court knows what the issue is, and the court can see that there's not a big disagreement between us as to where we're headed and what needs to be done. I'll just reiterate that I think total consecutive sentence is not supported.
Are you saying then the total consecutive sentencing is an abuse of discretion by the trial court?
I think it is, because I don't, in the abuse of discretion, I think he didn't give enough weight to the fact that he was a minor.
But he did talk about it
He
quite a
did talk
bit.
about it.
And he explained why he did not give weight to it.
He did, and that's one of the issues that we're raising. We think that was an abuse of discretion.
I'll say whether or not we would have done it that way, we have to evaluate it for
Well,
abuse of discretion.
and I understand that. I understand that. And again, I'm looking at the starting point, the principles of sentencing in our state. I start there, and then you kind of go back down to all these other factors, and our position is
Your position is to what degree, as I understand,
that's what Perry says. To what degree do you do consecutive sentences?
and those sentences should be greater than that deserved.
Exactly. That's our argument. Thank you.
All right, thank you, Mr. Flanagan. General Wilbur. All right, good arguments, good briefs. We'll take it under advisement. That concludes today's docket. We'll start back again tomorrow at 9:30.